Hey everyone, let's jump straight into today's explainer. If you are a law student, a legal professional, or honestly just someone fascinated by how our constitutional rights actually play out in the real world, you are absolutely in the right place. Today, we're breaking down a literal game changer from the Supreme Court of India, Arnesh Kumar v. State of Bihar. This is the definitive case on curbing arbitrary police arrests. By the time we wrap up, I promise you're going to have a crystal clear, highly structured understanding of the facts, the statutory laws, and the Supreme Court's ultimate sweeping ruling on police powers and personal liberty.
Okay, let's dive into this with a quick roadmap so you can organize your notes. First, the facts and legal issue. Second, the laws in question. Third, arguments from both sides. Fourth, the Supreme Court's reasoning. And finally, the Arnesh Kumar guidelines.
Let's start right off with Section 1, the facts and the legal issue. You know, before a case becomes a landmark precedent, it always begins with a human story, a dispute that gets the whole machinery of justice moving. And as you can see laid out in the timeline here, this one started as a domestic dispute. Back in 2007, Arnesh Kumar, our appellant, got married, but shortly after, things went south. His wife alleged that Arnesh and his family demanded a massive dowry. We're talking rupees 8 lakhs and a Maruti car. When her family couldn't meet those exorbitant demands, she claimed she was subjected to severe cruelty and thrown out of her matrimonial home. That led straight to an FIR under Section 498A and the Dowry Act. Anticipating that the local police were going to come in heavy and make an immediate arrest, Arnesh applied for anticipatory bail. But his applications were rejected, one after the other, by both the Sessions Court and the High Court of Patna. So, facing imminent arrest, he took it all the way to the Supreme Court.
And that brings us to the core legal issue the court had to tackle. Arnesh Kumar argued the police were basically weaponizing these anti-dowry laws, using them to automatically arrest entire families without doing any initial verification whatsoever. So the Supreme Court had to ask, do the police actually have the absolute unchecked discretion to just automatically arrest a person the second an FIR is registered? And on a broader systemic level, how can the justice system prevent mechanical arrests and routine jail time for offenses carrying a maximum punishment of up to 7 years? Keep that big question in the back of your mind as we evaluate the statutes.
Moving right along to Section 2, the laws in question.
Now, for you law students out there, reading the exact statutory text we've got here is absolutely crucial for mastering this jurisprudence. You really have to know the tools the courts are working with. First, we have the substantive offense at the heart of that FIR, Section 498A of the Indian Penal Code. This section penalizes a husband or his relatives for subjecting a woman to cruelty, and it carries a maximum sentence of 3 years. Now remember, this was originally designed with a very noble intent, to shield women from domestic cruelty, but, well, its actual application became highly controversial.
Now, what's really interesting about this slide is how the additional statutes create the procedural machinery around making an arrest. We've got Section 4 of the Dowry Prohibition Act, which specifically penalizes the actual demand of a dowry. But the real procedural heavyweights, those are in the Code of Criminal Procedure, or CRPC. Sections 41 and 41A govern exactly when police can make warrantless arrests and when they must instead issue a notice of appearance. Then, Section 167 outlines the magistrate's power to authorize detention if the police want to keep someone in custody past 24 hours. The interplay between those procedural rules and the substantive 498A charge, that is the exact battleground of this case.
All right, Section 3, arguments from both sides.
This case perfectly highlights a profound legal tension between two essential priorities: protecting the personal liberty of everyday citizens versus safeguarding vulnerable victims from domestic abuse. Let's impartially break down this comparison we have on screen. The appellant, the husband, argued that Section 498A had degenerated into a weapon of legal harassment. They pointed out that disgruntled spouses were frequently using it to implicate everyone in the family, even bedridden grandparents or distant relatives, just out of spite. They argued this Indian police culture of arrest first, regularize later, completely destroys a citizen's right to personal liberty under Article 21 of the Constitution, causing massive social stigma before a single shred of evidence is evaluated. Conversely, the state argued that dowry harassment and domestic violence are rampant, insidious social evils that happen behind closed doors and tragically often lead to dowry deaths. They contended that Section 498A was explicitly made non-bailable and cognizable to give the state powerful teeth to protect women. To restrict the police's arrest powers right at the threshold, they argued, would dangerously weaken the law, allowing the accused to intimidate victims or destroy evidence.
Which leads us perfectly into Section 4, the Supreme Court's reasoning.
With those vital arguments laid out, the court, in a judgment delivered by Justice Chandramouli Kumar Prasad, did not hold back. This was a highly critical, reformative exposition. Look at this quote here.
The Supreme Court explicitly stated that Section 498A has acquired a notorious reputation as a tool for legal terrorism. Wow, that is incredibly provocative, powerful language coming from the highest court in the land. They openly acknowledged that while the law's intent was protective, the sheer abuse of this statutory power had reached a terrifying level, literally destroying families through baseless arrests.
And they didn't just rely on anecdotes to make that claim. Look at the visual disparity on the chart here. Relying on data from the National Crime Records Bureau, the court pointed out the massive rate of arrests under 498A completely dwarfed the dismally low rate of actual convictions. This disparity proved to the court that police were routinely locking citizens up mechanically without anywhere near enough evidence to secure a conviction in court. The power to arrest was being heavily used, sure, but the actual justification for the arrest, entirely missing.
So the crucial point is how the court interpreted the amended Section 41 of the CRPC to fix this mess. They noted the legislature intentionally separated the power to arrest from the necessity to arrest for offenses carrying a punishment of less than 7 years. They established a strict two-pronged statutory test that police absolutely have to clear. Step 1, the officer must have a reasonable belief, based on objective material, that the person committed the offense. But actually, that is not enough. Step 2, the officer must record a specific, written conclusion that the arrest is necessary. And necessary why? Well, to prevent further offenses, stop evidence tampering, or prevent witness intimidation. If these two steps aren't collectively met, the police cannot make the arrest. Instead, they have to issue a formal Section 41A notice of appearance directing the accused to join the investigation.
And the Supreme Court didn't just point the finger at the police here. They turned their spotlight straight onto the subordinate judiciary. As you can read here, magistrates are not rubber stamps. Under Section 167 of the CRPC, when the police bring an arrested person to a magistrate asking for more jail time, the magistrate has a mandatory constitutional duty. They cannot just act as an administrative extension of law enforcement. They literally must actively read the police checklist, examine the recorded reasons, and ask that the police actually have a legal necessity to make this arrest. If those reasons are invalid, the magistrate must immediately release the accused.
Bringing us to our final part, Section 5. The Arnesh Kumar Guidelines.
The Supreme Court allowed the appeal, granted Arnesh Kumar provisional bail, and then went a massive step further. To root out arbitrary arrests nationwide, they issued mandatory directives for all offenses carrying a punishment up to 7 years. Students, read through the bullets on the screen here because you really need to memorize these rights-oriented directives. First, no automatic arrests under Section 498A or the Dowry Act. Period. Second, police must fill out a specific data-driven checklist containing the subclauses of Section 41, explicitly detailing why the arrest was necessary. Third, this checklist must be forwarded to the magistrate when seeking further detention. And fourth, if an arrest isn't made, police must serve a notice of appearance to the accused within 2 weeks of the case being instituted. These guidelines firmly establish that for minor and moderate offenses, arrest is the exception, not the rule.
Now, to make sure these guidelines weren't just ignored, because we all know how things can go on the ground, the court added some serious teeth. Look at the penalty for non-compliance. Any police officer who fails to comply with these directives will face departmental disciplinary action and contempt of court proceedings. And any magistrate who just mechanically authorizes detention without recording their judicial satisfaction, they will face disciplinary proceedings by their respective high court too. This strict enforcement mechanism was designed to force a total shift in the criminal justice system's culture.